Greetings to you, dear ladies and gentlemen out there, wherever you're watching us from. This is People Freedom Media, of course, but today I've come up with something special. I'm here for land law. The question may come out and says, what do you understand by the Torrens system? And discuss in details all the land tenure systems in Uganda. The question has two sections. I'm going to divide it into two for easier digestion. Part A, or section 1, says Torrens system. Then part B says the land forms or tenure systems in Uganda. Let's begin by Torrens system. Whatever we are going to say here, we are going to be listing. Get a pen and a piece of paper and see how maybe we can try to attempt together these questions in case you meet it in an exam. Now, first and foremost, let's talk about the Torrens system. You write that Torrens system. We are going to first write an introduction. You say introduction. Give a very brief background on what you understand by Torrens system. For me, I would say Torrens system was invented by Sir Robert Torrens in Australia. I repeat, Torrens system was invented by Sir Robert Torrens in Australia. Then you have to specifically set a purpose of the Torrens system. You continue and say purposely to provide certificate of titles to the landlords. Remember, now off record, this is off record now. First, stop there. Remember, before the 1900 of Uganda Agreement, the land was not owned by individuals, if you have to remember that. Instead, if you wanted to find out what concerns land, you could go and ask the neighbors and the clan leaders as well, okay? Or family heads and what have you, the leaders in particular. So, but when the signing of the 1900 of Uganda Agreement came, there was a system which was put into force in 1927, which was the Torrens system now, whereby people could own land, but on this land, remember, land was divided into two, the Milo land and the Crown land, whereby the 9,000 hectares were given to the chiefs and the king of Uganda. But the king of Uganda by then was King Kabaka Sekabaka Daudi Chwa. He was 4 years and he couldn't sign the Uganda Agreement. It was signed by the three men, Zakaria Kisingiri, Sir Apollo Kagwa, and Stanlas Mugwanya. When these chiefs were given authority to take over these people that were living on that land, to look after them, so these people were supposed to pay what we call osuru on that land, or envujo. Okay, they cultivated, they did farming, then they got that surplus, yields or harvests, and took to their kabaka, all these chiefs, as envujo, or some paid some little money as the usuru. But however, with the time, these chiefs came greedy for money, and they overtaxed these people with a high rate of usuru, okay, exorbitantly. They wanted to exhaust the indigenous people, and then the white says, or the British said, this will not work, because by doing that you end up evicting people from the land. So they introduced the Torrens system, which was purposely for registering of land titles, however giving rights to the vibanja holders to also have what we call security of tenure. Now let us stop there and we go back to our question. That one is relevant just for general knowledge. Now, when you give such an introduction, we stopped that purpose was provide certificate of titles to the landlords. Can give a live example how the Torrens system come in. For example, if imagine, let's imagine that you buy or you bought a car from someone. You bought a car, but this car was second hand, not brand new. All you want is to prove that this car belongs to you, okay? Then, and you do not have to carry a briefcase of all the documents full of what receipts showing who owned this car before you bought it. So you get a single logbook with your name on it. Now this is how the Torrens system works on land. You only have to get your name registered on a single certificate of title, which in law we call a duplicate certificate of title. But eno ewaffe tukiyita ekyapa ekiri original, naye mu mateeka bakiyita duplicate certificate of title. With that alone, I think someone as an examiner would have understood what you are relating to by the Torrens what? Or Torrens system. Now, after giving an example, you come and say, don't forget to mention of the three fundamental pillars of the Torrens system. You say that Torrens system has three main pillars or principles, namely, one, we have what we call the mirror principle, the curtain principle. Let me write the mirror principle, three main pillars, namely the mirror principle, the curtain principle, and thirdly, there's what we call the indemnity principle. The indemnity, or you can call it insurance. Some call it insurance principle. After listing these principles, you must talk about briefly each. What do you understand by these principles? Now, you go ahead and say the mirror principle. The mirror principle establishes that whatever is on the certificate of land title must reflect in the register or in the land registry. For example, if there is a caveat on the certificate of title, it must reflect in the register. If there is mortgage on the certificate of title, it must also reflect in the register. There you can go. Failure to reflect, then it is not certificate of title in the eyes of the buyer or purchaser. If you want to buy land and you find out that this land has mortgage, but this mortgage does not reflect on the certificate of title, then that land must be having a problem in short terms. That is, then you go, you leave it at that. Secondly, let's talk about the curtain principle. The curtain principle draws a curtain on the certificate of title, whereby one does not need to investigate who were the previous owners of the land before it was registered. Okay? You don't have to look for the ancestors of this land before, on how this land was obtained. You don't have to find out who are the previous owners of the land. That is the curtain it draws. Thirdly, we have to talk about the indemnity or insurance principle. The indemnity, remember, the government now is the custodian under the Ministry of Lands, is the custodian of certificates of land title. Therefore, it affirms and guarantees that the registry or the register is correct. Any mistake which is done on the certificate of title and it causes loss to the registered proprietor, that registered proprietor is subject to compensation. Okay? That is what we mean by insurance principle or indemnity principle. After showing that, you have to proceed and say, don't forget to talk about what we call indefeasibility of title. Let me write and say indefeasibility. You write and say indefeasibility of title. Indefeasibility of title means that a certificate of title is a conclusive evidence of land ownership. Once you have a land title registered in your names, once your name is entered into the registry, official registry, then you automatically become the owner of the land and you are issued a certificate of land title. And Section 59 of the Registration of Titles Act Cap 240 confirms that that title is indefeasible. It cannot be altered. That is Section 59. Now, after you mentioning that Section 59, you go ahead and tell us that when does this title become defeasible? When can it be cancelled? Because it can be cancelled anyway. Under Section 77, I will mention about that, of the RTA or registration titles. When you look at Section 77, a land title can be cancelled, and which power is vested in the High Court to cancel out a certificate of title, but on grounds of fraud. Now that is a very huge and a giant exception under which a certificate can be cancelled on grounds of fraud. Okay? Now, having seen that a title can be cancelled, you go ahead and tell this gentleman, in the landmark case of Kampala District Land Board and another versus Chemical Distributors Limited, a case of 2008, court held that a title is a conclusive evidence of ownership of the land. Once you have a registered certificate, you are the true owner of the land. However, it can be indestructible on grounds of fraud. Once fraud is proved or proven, that title must be cancelled. Tell this examiner that for fraud to exist, but you first define fraud. A title can be destructible or can be defeasible on the grounds of fraud. But what is fraud? Fraud was defined in the case of Frederick J. Zawe versus Orient Bank and others. The case of 2006. It defined fraud as the intentional perversion of truth, which on reliance induces a party to part with their valuables and lose their legal rights. Or you put a full stop and keep quiet. What are the forms of fraud? For one to prove fraud, that fraud existed, you need to prove one, there is what we call actual fraud. Actual fraud. Actual fraud means dishonesty. Talk about briefly. Dishonesty can mean dishonesty. You're right. It can mean a cheat. You are cheating. It can mean trickery or a tricking. You know that word. Trickery. In order to deprive one's rights or to deprive one's property. In order to deprive one's legal rights. You have talked about actual fraud. Now, actual fraud can take a direction of, we prove actual fraud. Someone can forge documents, can do forgery. One may make forgery of documents. One can forge signatures. Can forge a signature. In particular in land now, it can be on the transfer forms. Or one can make kyemuyita ekyapa ekikyupulye, can make a parallel certificate, can make a parallel certificate of title. Now, under this, there must be a direct participation of the party, of the fraudulent party. This party must participate and it must have a direct conscience of mind that they are doing what is not acceptable legally in order to cheat the other party. Another form of fraud, it can be constructive fraud. When we say constructive fraud, what do we mean? Constructive fraud is when you can ignore some lights, the red flags in such a transaction that may earlier indicate that there must be something wrong in this transaction before even you transact. For example, in J.K. Zabwe, in Frederick J.K. Zabwe, the party which was given what we call powers of attorney misused the powers of attorney by applying for a huge amount of loan in the Orient Bank. Okay? Now this is off record. Let me explain. They applied a huge amount of loan in the Orient Bank, but the bank never carried out due diligence or what we call another sense of why would Mr. Zabwe, a prominent lawyer, a senior counsel, a senior lawyer, who was not benefiting on zero profits or on zero, interest, allow these people to give security, to give the land of Mr. Zabwe as a security to obtain such a loan. It is taking a blind eye on certain things which are obvious, which even a lay person can see. So when you take a blind eye on certain things, you don't do what we call due diligence. You must have participated in the fraud. Ignoring the existence of a third party. Once you see a third party existing on the ground, for example, if A purchased land and has what we call equitable interests in that land, and another buyer becomes and buys this land, and for them they assumes very fast and take advantage of party A's loopholes. They go and bribe an official in the register. They register this land very fast in their interest. This registration is considered fraudulent as long as these people were there on the land and they were actually utilizing the land, what we call actual possession. Therefore, the registration is rendered fraudulent. The fourth one is ignoring a caveat. Deliberate ignoring of the caveat. Under section 123 of the Registration of Titles Act Cap 240, that provides that any person claiming to having interest in that specific land, they may lodge a caveat with the registrar. You can open up that section 123 of the RTA. So now your conclusion will include whatever I have talked about, but very briefly this time. The introduction, in the middle there. You don't have to repeat everything. Once fraud is justified by court, the title can be cancelled under section 77 of the Registration of Titles Act Cap 240. Thank you very much for watching. I very need to sign out for now and wish you a good stay. But however, now in the next video, I'm going to tackle on the types of tenure systems in Uganda. Remember, it is one question. Whenever you're writing, you write speedy, but only I was explaining, you know that it takes a lot of time. But when you're writing, we are going to tackle now the types of tenure system in Uganda. That was part A. Thank you very much. Stay tuned.